Nothing explosive was said in this exchange, and that is precisely what makes it so alarming. There were no dramatic outbursts, no shouted accusations, no cinematic, gotcha moment designed to dominate headlines or fuel viral clips. No single sentence landed with the force of a political bombshell, and yet, what unfolded during this hearing was far more disturbing than any theatrical confrontation could have been. It was a slow, methodical display of evasion, deflection, and procedural maneuvering in response to questions that went directly to truthfulness, authority, and the constitutional limits of power. This was not chaos, it was control, and that is why it matters. The hearing did not begin with ideology or rhetoric. It began with a narrow factual inquiry about the MAR, a Lago classified documents case. The question was simple and specific. Did you testify before a grand jury that President Trump had declassified the documents at issue? This was not a trick question. It was not framed to invite interpretation. It was a yes or no inquiry about sworn testimony already given under oath. In any system grounded in accountability, such a question would warrant a direct answer. Instead, the response immediately drifted away from substance. Rather than addressing what was said, the answer redirected attention to the existence of a grand jury transcript described as the best evidence of what was testified. The implication was clear. The truth exists somewhere else, somewhere inaccessible, somewhere deferred. Responsibility was shifted away from the witness and onto a document that remained sealed, unavailable to the public, and explicitly denied release by a federal court when requested by a news organization. When this contradiction was raised, the response shifted again. Now the argument was not about what was said, but about a willingness to work with the department and the courts to release the transcript at some future point. This maneuver is important to understand. It creates the appearance of transparency without actually providing it. It gestures toward openness while maintaining total control over disclosure. The truth is always just out of reach, always contingent on a process that never quite resolves. This is where the exchange moved from frustrating to revealing. Under Rule 6 of the Federal Rules of Criminal Procedure, a grand jury witness is not prohibited from discussing their own testimony. This is settled law. The committee was not asking for classified information. It was not asking for deliberations or the identities of jurors. It was asking whether a specific claim was made under oath. That distinction matters. Oversight is not about relitigating cases. It is about assessing credibility. When that legal reality was stated plainly, the response did not change. There was no clarification, no denial, no confirmation. Instead, the premise of the question was challenged. The framing was questioned. The authority of the committee was implicitly resisted. The exchange became circular, not because the issue was complex, but because complexity was being manufactured as a shield. That pattern would define the rest of the hearing. The focus then shifted to promises made during the confirmation process. Under oath, the director had assured the Senate that FBI employees would be protected from political retribution. He stated clearly that no agents would be punished for their case assignments. These assurances were not rhetorical flourishes. They were foundational commitments, offered in exchange for confirmation to one of the most powerful law enforcement positions in the country. The Senate's role is not ceremonial, it is constitutional, and oversight exists precisely to test whether those commitments survive contact with power. The follow-up questions were therefore both legitimate and necessary. Were there any plans, discussions, or actions taken to punish FBI agents associated with investigations involving Donald Trump? Were any personnel decisions influenced by political loyalty or perceived disloyalty? The answers again avoided direct engagement. Litigation was cited. Allegations were dismissed as unproven. Carefully chosen language created narrow deniability while leaving broader concerns untouched. Words like solely and alone appeared repeatedly. These qualifiers are not accidental. They are legal tools by framing questions in the narrowest possible terms. They allow a witness to technically deny wrongdoing while evading the spirit of the inquiry. But oversight is not a courtroom cross-examination. It is a truth-seeking function, and when answers are constructed to evade rather than inform, that evasiveness becomes part of the record. The hearing then moved from abstract assurances to concrete consequences. Brian Driscoll was no anonymous bureaucrat. He was a career FBI agent with more than 20 years of service. He led the Newark field office, His record included a Medal of Valor and Shield of Bravery awards by any professional standard. He was the kind of institutional leader agencies rely on during crises. His termination was not routine. It was not explained as performance-based. It was justified in a letter citing Article 2 of the Constitution. That justification is not a minor technical error. Article 2 vests executive power in the President of the United States. It does not grant an FBI director independent removal authority grounded in presidential powers. That distinction is fundamental. When asked under what authority such an action was taken, the response once again retreated behind pending litigation. The question was not answered. This is a recurring theme worth emphasizing. Accountability does not collapse when leaders lack information. It collapses when they refuse to answer questions they clearly understand. The repeated invocation of litigation in this context does not function as legal necessity. It functions as insulation. It prevents scrutiny while allowing actions to proceed unchecked. Questions about political influence followed logically. Were there discussions with senior political figures about personnel decisions? The answers were carefully hedged, not that I recall frequently, but only in appropriate contexts. Homeland security, interagency coordination, necessary collaboration, yet no clear boundary was articulated between policy consultation and operational control. That ambiguity is precisely where institutional independence erodes. Institutions are not captured through dramatic purges or public declarations. They are bent quietly, through informal channels, through blurred roles, through expectations that are never written down. When senior officials frequently consult political actors about interagency operations, the distinction between advice and influence becomes dangerously thin. Oversight exists to clarify that boundary in this hearing. That clarity was never provided. The downstream effects of these decisions are not theoretical. They are operational. Independent analysis indicates that roughly 20% of FBI agents have been diverted from specialized investigative work to immigration enforcement operations. This figure is not symbolic. It represents thousands of agents reassigned away from counterintelligence, child exploitation, human trafficking, and domestic security investigations. These roles are not interchangeable. An agent trained to identify foreign intelligence operations cannot simply be replaced overnight. An investigator specializing in crimes against children carries expertise that takes years to develop and cannot be recreated through rapid reassignment. When those agents are pulled away, the cost is not immediately visible. Threats are not always missed in dramatic fashion. They are delayed. They go uninvestigated. They mature quietly. This is why the refusal to answer direct questions about reassignment mattered so deeply. Were agents investigating crimes against children reassigned to immigration enforcement? Were counterterrorism agents diverted from their missions? These were not ideological challenges. They were operational inquiries. The response was not denial. It was indignation. Assertions of safety replaced explanations of policy. Statistics were offered, weapons seized, children recovered. These numbers may be accurate, but public safety is not measured solely by enforcement outputs. It is measured by resilience, by prevention, by what never happens because experienced professionals were allowed to do their jobs without interference, fear, or political pressure. When institutional capacity is weakened, adversaries do not need to act immediately. They wait. Throughout the hearing, Senator Booker was not performing outrage. He was documenting patterns. He traced a line from promises made during confirmation to personnel decisions taken afterward, to shifts in operational priorities, and finally to the erosion of institutional expertise. This is how serious oversight works. It does not rely on viral moments. It relies on consistency. And here, inconsistency appeared repeatedly. The most revealing moments were not the sharp exchanges near the end of the hearing. They were the quieter ones earlier on. The refusal to answer a simple factual question. The insistence on process over substance. The repeated deferral to future disclosures that may never occur. These moments rarely dominate coverage, but they are the ones that matter most. This hearing was not about partisan conflict. It was about governance. It was about whether federal law enforcement remains grounded in professional norms or becomes shaped by political loyalty. Agencies like the FBI are not designed to serve individuals. They are designed to serve the Constitution. When leadership blurs that distinction, the rule of law weakens not through dramatic collapse, but through gradual erosion. Nothing explosive was said here. That is the point. Leadership failures do not announce themselves with sirens. They reveal themselves slowly through omissions, through deflections, through unanswered questions that should have been easy to answer. This exchange deserves attention not because of what was shouted, but because of what was avoided. If you care about national security, institutional integrity, and accountability that produces records rather than talking points, this is the kind of moment that deserves careful scrutiny. History is not shaped only by scandals, it is shaped by patterns, and patterns like these, once established, are difficult to reverse.